Hello everyone. I'm glad you all could join us this Friday night. We took a short break from our weekly webinars, but now we are back and are ready to educate and empower tenants. Tonight, we are discussing the extension of the eviction moratorium, and we're gonna basically, explain like what it means for tenants tonight. We are happy to have Jesse Gribbin join us tonight, who's an amazing attorney who focuses on tenants' rights, and he also works alongside Palante and helps us with assisting our clients. Just everyone, have a good time tonight. I hope everyone is able to, soak up all this information, and we will be having a Q&A once Jesse is done with his presentation or what he's discussing tonight. So Jesse, if you're ready, you can start now.
Hi, good evening, everybody. My name is Jesse Gribbin, and I'm an attorney with the law firm of Himmelstein, McConnell, Gribbin, Donahue, and Joseph. As Chakati just said, I work very closely with Palante. I've worked with Palante now for many, many years, and we've successfully collaborated on several major cases. I honor and grateful for the opportunity to speak to you guys this evening, and also collaborate with Palante, who does tremendous and necessary work, for tenants throughout the city. So I'm going to be as brief as I can, and I wanted to just fill everybody in with regards to the New York State Legislature's expansion of the eviction moratorium through and including January of 2022. So just by brief way of background, initially the New York State Legislature passed, hold on one second, I think I can move over and do this on my computer. Okay. Can everybody hear me? No.
Yes, we can hear you, and you'll just want to make sure that you're out on the phone.
Can people hear me?
Yes.
Yes, we can hear you, and just remember to jump onto the English channel.
Oh, okay. And I do that by
your meeting controls on the bottom of the screen that should say there should be a language globe, and will allow you to choose Spanish. It's a language interpretation globe. You can choose English. I'm sorry.
All right, I got that. All right,
Great.
Sorry everybody. So
you sound good.
To continue, okay. So initially in December of 2020, right, at December 28th of 2020, right as we were sort of entering the new year, the New York State Legislature enacted the most progressive eviction moratorium in the country. And that eviction moratorium was set to expire May 31st of 2021. And that eviction moratorium didn't just stay the last violent act of eviction, right? Physically expelling people from their homes and putting them on the street. But that eviction moratorium also stayed all of the proceedings, and it actually precluded landlords from commencing cases against tenants. So the scope of the stay was very, very broad. And the intent of the legislature in doing that was, again, not just to stop landlords from that last violent act of eviction, but also stopping landlords from proceeding with that eviction case. And the thought was that enforcing tenants to have to endure the stress and anxiety related to an eviction case was also something that needed to be guarded against and protected from. And that eviction moratorium was set to expire in May 31st of 2021, but the New York State Legislature renewed that and was extended through and including August 31st of 2021. So what happened though in the month of August last month is that right after the New York State Legislature passed the eviction moratorium, and again, one of the broadest, most inclusive moratoriums in the country, landlords in New York City mounted a constitutional challenge in federal court. And what they said was that the New York law was unconstitutional because it infringed on landlords' due process rights. And part of that was that the landlords, according to their argument, they had no ability to challenge tenants' attestations of hardship, right? Either economic hardship or being at increased risk for disease if they got COVID, right? That's what tenants could do. They could submit a hardship declaration, and that would just stop everything in its tracks. And what the Supreme Court of the United States, which is a very conservative court, it's packed with predominantly Republican appointed judges, what they said was that that was unconstitutional. And the unconstitutional, again, was that the landlords couldn't challenge the tenant's attestation of hardship. So they struck down the New York State Eviction Moratorium law in August of 2021, recently. And what the New York State Legislature did when they recently, in early September, I think September 2nd, when they enacted the latest version of the eviction moratorium, is that they rewrote the sections of the law that the Supreme Court found to be problematic. And what they did was they put in place an ability for landlords to challenge tenants' attestations of or COVID hardship declarations. And I'm going to talk about that for a little bit. And that is essentially now the only change in the eviction moratorium that now extends out through January. So let me just be very, very clear about a couple things. Nobody who fills out a COVID hardship declaration can be evicted from their home before January of 2022. Right? That's the law. Now, whether a landlord can proceed with a court case or whether a landlord can file a new court case, those things have changed slightly. And in the case where a tenant provides their landlord with a COVID hardship declaration, the landlord can nevertheless start a case against that tenant if they think that the tenant's declaration of hardship is untrue. And they can then start a case against that tenant. Similarly, if there's a case pending against the tenant who's put in a COVID hardship declaration, the landlord can challenge that COVID hardship declaration and have a hearing, if you will, on whether or not the tenant's declaration is indeed truthful. So just to sum up, everybody who either was impacted economically by COVID, right? And that means either you or a member of your household, the household saw some sort of economic loss because of COVID, and or you are at increased risk of severe disease if you contract COVID. Those are the two criteria on the COVID hardship declaration. If any tenant truthfully falls into either one of those categories, they should give their landlord the COVID hardship declaration, because that still is what triggers the protections in the current eviction moratorium, right? So if you don't fill out the COVID hardship declaration, cases proceed on their normal course, right? So that's the first step. Now, rather than what it was before, which was a tenant fills out that COVID hardship declaration, and that's the end of it, right? The case comes to a dead halt. Landlords have no ability whatsoever to challenge a tenant and say, I don't think you lost income, or, again, if you're over the age of 60, the CDC says you're at increased risk if you contract COVID. So if you have a birth certificate and you're over 60, I don't see how any landlord could challenge that. But if you're not, presumably a landlord could say, I don't believe that you're at increased risk for COVID, and therefore I want to have a hearing on the validity of your hardship declaration. And that in and of itself is the big change in the eviction moratorium from the prior versions, right, that were passed in December of 2020, December 28th of 2020, and then later as that was about to sunset, and they passed an extension right at the end of May of 2021. In those versions, it was a tenant puts the hardship in and you're done. Now it's the tenant puts the hardship in and the landlord may or may not challenge that. And they have to have a good faith basis to challenge it, right? It's not just that they can challenge at will. They have to put forth some sort of affidavit, some sort of reason why it is that they're challenging a tenant's COVID hardship declaration. So, I want to sort of be quick. I don't want to sort of go on and on. I wanted to kind of just give a sort of the broad outlines of what the eviction moratorium currently looks like. It still provides very robust protections for tenants. It's still something that tenants have now available to use as far as protection from being evicted, and it's still a very, very, very powerful tool and something very, very much that tenants should avail themselves of. The last thing I want to talk about just a little bit, and and again, whatever questions folks have, we could talk about, is the, and I know because I've done a bunch of these with Palante, is the push now for any tenant who is eligible to submit an application to the New York State Emergency Rental Assistance Program, or the acronym being Ewrap. And again, there's certain income requirements and there's certain documentary proof, and Palante's done a tremendous job at helping folks gather the necessary documents that they need to apply for the program. But the program has a lot of money, and an application to the program, that too will stay any non-payment proceeding. So any tenant who has been sued by their landlord for non-payment of rent, they absolutely, should, if they're eligible, submit an application. Yes, it should submit a Ewrap application, and that Ewrap application will stay any non-payment proceeding in housing court until that application is processed and either approved or denied. And I can talk a little bit more about the Ewrap stuff if those are questions that people have. So again, with that, I want to sort of conclude and open it up. I don't want to kind of drone on for too long, but questions I'd be glad to answer, and sort of, I think a discussion is most productive.
Well, we do have one so far. Is there a new COVID declaration hardship under new moratorium in place? The first question from this guest was, good. Is the COVID declaration hardship that Governor Cuomo passed followed by, and I think they're related, is there a new COVID declaration hardship under new moratorium in place?
Right. So the COVID hardship declaration is the same declaration from the time that the law was first passed back on December 28th of 2020. The declaration itself has not changed, right? And anybody who's submitted a declaration already to their landlord or to court, they do not have to file a new COVID hardship declaration with the passage of this latest extension. I think the best way to understand the eviction moratorium is that it was enacted in December of 2020. It was set to expire at the end of May. The legislature renewed it and they extended it again till the end of the summer, till the end of August. And then it was extended once again to the end of January of 2022. So it's the same law, it's just been extended, and it's been modified because the Supreme Court struck down certain parts of the eviction moratorium in New York, and the legislature then had to address those issues that the Supreme Court of the United States said was violative of landlords' due process rights under the US Constitution. And that's what led to some of these changes that I talked about. But the same hardship declaration, right? The same ones that have been circulating and have been out there now for, 9 months or so, it's the same declaration.
So yeah, we don't have additional questions at the moment. If you wanted to continue on to.
Sure. I actually will talk about a couple of other things that I've seen and that I wanted to kind of maybe touch upon. One thing that we've begun to see some more of, and we saw this throughout the pandemic, was landlords suing tenants rather than in housing court, suing tenants in Supreme Court, right? There's different courts. There's a different, courts for, in New York State. There's the civil court, which the landlord tenant court is part of the civil court. And there's a special court for landlord tenant proceedings. But then there's the Supreme Court, which is a court of what's called general jurisdiction. They do everything there, right? Everything from family law to, huge money, commercial deals to, disputes about, contracts. It's a general court of general jurisdiction. And landlords we've seen have begun to initiate cases in Supreme Court. And we find that to be quite interesting for a few reasons. And that is that in Supreme Court, generally, landlords aren't seeking what's called a possessory judgment, right? They're not trying to evict anybody about the money that's owed, right? In housing court, why landlords start cases there is because if the tenant doesn't pay, the tenant loses the apartment, the tenant gets evicted. Landlords now are going into Supreme Court saying, we don't care about getting back the apartment. We don't care about evicting the tenant. The only thing we care about is the money. It's only about the money. And they're trying to secure judgments against tenants in Supreme Court. And really what I want to do is make sure people are aware of that and don't ignore if they get served with papers in Supreme Court. We've seen quite a few now, folks that had cases pending in housing court, then turn around and be sued in Supreme Court. And, again, it could be confusing. You could say, I thought I already got these papers. They kind of look the same, but you have to be very, very vigilant and be very, very careful. If you get any sort of official or court looking papers, you got to take that very, very seriously. And you gotta either figure out how to deal with it, or you got to reach out for help, and you got to call Palante, or you got to avail yourself of other resources and legal services that are available to tenants throughout the city. Yeah. The other thing I'll say too is one thing that's beginning to shift and change is previously there was not much going on in housing court as far as calendaring new cases. So folks were getting served with court papers. They were not doing much, right? There would be some notice on it that they should call, and maybe they could give an answer, orally by phone. And people weren't really, doing that, but nothing bad was happening. No cases were being defaulted upon. Everything was just sort of, at a standstill. And that now seems also to be shifting and changing. And what we're hearing from court administration actually is that newly filed cases, so cases that are being filed now in September, are cases that are sort of being put at the top of the queue and are going to be conferenced and assigned to judges first before cases that are pending prior to September. So that's another thing to keep in mind. Any other questions out there?
Yeah, follow up to a previous one. So it is a valid COVID declaration hardship. I heard that Governor Cuomo's declaration was no longer valid. It was said multiple times on the news.
Right. So it's the same COVID hardship declaration. What the Supreme Court of the United States found was that it wasn't fair to landlords, right? I mean, I couldn't disagree more, but this is what the Supreme Court said, that it wasn't fair to landlords to not allow landlords to challenge a tenant's COVID hardship declaration, right? That if you didn't allow a landlord to be able to try to take on a tenant, what the Supreme Court didn't like was that what the law said was once the tenant puts that in, that's it, it's done. And the court said you can't do that. You got to give landlords a chance to to challenge that. That was what was the problem. And that's why the New York State legislature went back to work and they rewrote the law in the way that I described, which allows the landlord to challenge a COVID hardship declaration. And likely what will happen is the landlords will challenge this new law. But like the old law, what might happen is that the tenants get the benefit of the new law because it'll take several months, like it did the last time, for the landlords to litigate that all the way up to the Supreme Court. But I'm going to be honest, I actually think what the legislature did here was they addressed the issues that the US Supreme Court put in place. So without too much of the legal in the weeds kind of discussion, the answer to your question though is the COVID hardship declaration very much is still something that tenants should use, can use, and will use. And the only difference now is the landlord could turn around and say, Mr. or Mrs. Tenant, I don't believe you. I don't believe that you suffered economic harm. Now you have to prove it, right? That's what's changed. That's the only thing that's changed. Everything else has remained the same.
Buenas noches, soy Agustín Martínez. Primeramente quiero darle las gracias a doña Elsia por ser ángel guardián y me consiguió el pago de mi renta atrasada. Mi pregunta es que mi renta está al día y el landlord me está cobrando $2,000 de hace más de un año, de gastos del abogado de la corte, y nunca he podido tener mi cuenta en cero debido a ese cobro.
I'm not sure I understand the question. You might have to, I'm not sure I understand the question.
All right, we'll have a clarification possibly posted later. What is the tone of the New York Supreme Court with such cases for money judgments coming out of the New York Housing Court? Is Ewrap application allowing for a stay in proceedings?
No, very much. The answer to that would be no. And Supreme Court is going to deal with these cases in a summary fashion, right? These are cases that in Supreme Court, they're for relatively small amounts of money, not small amounts of money to us, but small amounts of money, 20, could be 10,000, 15,000, 20,000, 8, right? Whatever it is. And it's not a case that can lead to a tenant being evicted, right? No tenant can get evicted if the Supreme Court says you owe your landlord $8,000 or $12,000 or $20,000. You don't lose your apartment. What happens is they have a judgment against you, which is worth the paper it's printed on if you can't pay. Nothing. There's no debtor's prison in the United States, right? Nobody gets thrown in jail because they have a debt. You know, it messes up your credit. Yeah. You can enforce a judgment, right? You can put liens on bank accounts or liens on your wages to collect. You could do all those things. But what can't happen is you can't lose your apartment. You can't be homeless if you don't pay that money to the landlord. So, you know, no, the answer to that is no. They don't stay the Supreme Court cases because the stays are all about the policy behind the stay, right, is that a tenant owes money, right? And the reason why a tenant owes money is because during COVID, they suffered economic harm. They were laid off. They couldn't work. And they put in this application for Ewrap. And while that application is pending, the landlord is going to be able to put that person in the street. That's crazy, right? That doesn't make any sense. Allow the landlord to get paid. Give the tenant some time, right? If the eviction is not at stake, which is what's going on in Supreme Court, and the landlord just gets a judgment against the tenant, then Ewrap will be processed in due course. And if Ewrap pays it, judgment satisfied. The case is done, right? So in that regard, no judge in Supreme Court is going to stay any case pending Ewrap, because like I said, the reason for the stay pending Ewrap is to keep people in their homes while they wait for this money to get processed. There's another reason why the New York State legislature extended the eviction moratorium, right? It's like we can't have people being thrown out in the street while they're waiting for the release of all these monies to make the landlords whole for rent that wasn't paid, right? So that's the reason for the stay. That's the reason why those proceedings can't continue, because you can't let people be evicted while they're waiting. Supreme Court, you don't have that dynamic because it's only about the money and a judgment. So the answer to that, unfortunately, is no, they won't stay a case in New York Supreme Court for pending Ewrap application.
Just to remind the guests who are present that we do have interpretation in Spanish via the three dots. Hay interpretación en español, three dots on the lower corner of the screen, and language interpretation, and then Spanish, and done. And we are taking questions. Please post your questions in the chat, in the Q&A. I'm sorry, not in the chat, and we'll be able to monitor that. Poner plantear. Sorry, thank you. What is the is the New York Supreme Court friendly to the tenants due to COVID hardship declarations and Ewrap application?
Yeah, so again, the COVID hardship declaration and the Ewrap application wouldn't be applicable in the Supreme Court context.
Will the New York, I think this was alluded to in another answer that you gave previously, will the New York Supreme Court hold off from a money judgment while awaiting Ewrap?
No, I don't believe they will. I don't believe that they will do that.
We don't have any pending questions, so if you wanted to add anything, or
Sure.
interpreter has a question.
Sure. Right. So I think your question is about sort of the criteria in a COVID hardship declaration. But what I think you might be doing, and what I think might be happening a little bit, is that the criteria for the Ewrap application, right? That's the application for assistance with the owed rent. That's purely an economic sort of criteria and analysis. The COVID hardship declaration is something totally different. And that's a declaration that tenants can make. And I think Palante has it, and they have it available, maybe even on their website. That's a declaration that tenants make to get the stay, right? To stop the eviction proceeding from happening, from stopping the landlord from suing them in housing court, right? That's a different document. It's filling that out doesn't necessarily mean you're seeking help in paying the rent. That's an Ewrap application, and that's purely an economic sort of analysis, right? It has nothing to do with your increased risk for COVID or that. But the COVID hardship declaration, that does have two criteria. The first one is economically harmed by the pandemic, and the second one is you're at increased risk for severe disease if you contract COVID. So those are the two distinct. You could qualify on both accounts, right? You could absolutely check both boxes, and a lot of tenants do, but you don't have to. If you qualify under one, the declaration is valid unless now the landlord challenges it and is able to prove to a judge that you lied and you're not at increased risk for COVID, or you didn't suffer economic harm, etc. Okay, so I think that might be what the confusion is.
So we do have a question in Spanish, so
Sure.
I'm going to read out. Mi pregunta es que siempre en el bill de mi renta hay un cobro de $2,000, y cuando llamo al landlord me dicen que es de cobro de más de 2 años que tuve en la corte, y me dicen que ese cobro es del abogado de ellos.
Okay. They could put whatever they want on a bill. I don't know what, if you went to court and they paid their lawyer $2,000, they could put it on a bill to you. It doesn't mean you have to pay it, but I don't think there's anything you can do to, this happens a lot. We write letters sometimes and we ask landlords to take, it's their records, it's their bills, it's their statements. I don't think that, I just don't, again, them putting it on a bill, it's obnoxious. It causes grief and anxiety. It's not pleasant to see, but it's just that. It's just their statement to you. It's not as if you owe that money. It's not as if you have any obligation to pay that money. And I don't know if there's anything as a practical matter anyone could do to get the landlord to take that, to eliminate that, charge from your bill. I don't know if that's something that, I don't think there's any legal challenge, or if anybody would even do that, right? Sort of take the landlord to court to say, fix this gentleman's bill and take this money off the account. I don't even know if that's something that would be an actionable sort of thing that you could do in court.
Disculpe, yo debo 5 rentas, no he podido pagarlo. ¿Qué puede pasar?
Yeah, so I guess the question is, and I assume the answer to this is yes, if those months of rent accrued, if they came due during the pandemic, and the reason why you owe the money is because you suffered losses during the pandemic, you should apply for an emergency rental assistance program grant. And you should do that, and you should get in touch with Palante and they can help you do that. There's ways to do that, even if folks are undocumented, if there's a member of the household who's a citizen or a green card holder. It's not something that necessarily would preclude if you're undocumented. So that's the approach. There's a lot of money available. The program has not rolled out in a great way, but money is beginning to flow to tenants. Landlords want the money, and they're participants in the program. Anecdotally, we're starting to hear that money is beginning to be issued. That's what you should do. You should apply for a grant, and if you're eligible, I assume the grant will be provided.
Was there anything in the eviction moratorium that allows the landlord to pay their lawyers? If not, who pays this amount?
There is nothing in the eviction moratorium about payment to the landlord's lawyers. I don't believe that any tenant should be worried about having to pay their landlord's attorney's fees in any COVID-related case, meaning a case in which arrears accrued because of COVID. I don't believe that judges are going to award a landlord attorney's fees under those circumstances. And when I say those circumstances, what I mean is a tenant fell behind in the rent because they lost income or because their household suffered economically during COVID and their landlord sued them. And they eventually, either through an Ewrap grant or somehow otherwise, made the landlord whole and paid back all of the rent. I see no scenario in which a housing court judge will then say the landlord is entitled to his legal fees.
So that's the end of questions for now. If there's other topics that you wanted to jump into, just to.
No, I mean, I think sort of getting folks up to speed on the new provisions of the eviction moratorium. That's what we wanted to do. That's what we wanted to inform folks of. I want to sort of stick on that topic. I wanted to let folks know a little bit about sort of what we're seeing as far as landlords now looking to Supreme Court as a different forum, a forum where I think they're going to get quicker relief, put more pressure on tenants to make payments quicker. I think landlords sort of saw that cases in housing court essentially were sort of, moving either not at all or at like a glacial speed. And they might have recognized that a little bit and decided to move forward and sue folks in Supreme Court a little more often. And we gotta be on guard about that. We gotta look at that, and we gotta sort of see if there's some potential, maybe a legislative fix to this. Folks need to be aware now, much more so. If you get court papers, you have to deal with them, right? Meaning you can't sort of assume we're in the middle of the pandemic and nothing terrible is going to happen, so I can just sort of wait and ignore this. That was probably decent enough thing to do for many, many months during the pandemic, but now more. You get court papers, you have to take them seriously. You have to get in touch with folks. You have to advocate either for yourself or get yourself a free lawyer. What they're doing now in housing court, and they've really, and it's a terrific thing, they've expanded the right to counsel significantly. Most folks are going to qualify and get a free lawyer. That's part of the intake process now in housing court, is getting tenants free legal representation at that initial court appearance. So that's something also that folks should be aware of, and absolutely avail themselves of free counsel. Since right to counsel took hold in New York, we've seen that it works, right? When tenants are represented by attorneys, evictions drop significantly. That data has been made plain now, and we've seen that play out now over a year and a half, 2 years, and it's very, very clear. Evictions have dropped dramatically as a direct result of tenants having legal representation, not having to deal with their landlords and battle their landlords on their own in court. So everybody should be aware that they likely have the right to a free lawyer if they're sued, and they should avail themselves of that.
If Ewrap is not approved, tenants then wait for a court date in person or virtual to take place. On the court date, tenants may also inform the judge about heating issues and being discriminated.
Oh, good point. Thank you. Yeah, so that's actually something I'm glad that was asked, because I wanted to make that clear. It's something we've talked about in previous Palante forums, right? That just because you didn't pay rent for a bunch of months during the pandemic, it doesn't mean that you necessarily owe that money, right? If you have conditions in your apartment, so, anything, right, from, mice or roaches, broken floorboards, deteriorated cabinets, anything that's a housing maintenance code violation, you should call 311, should get those reported, get those on record. That likely warrants what's called an abatement of rent. You can go back 6 years. So it would precede the time period that you weren't paying, and it would then cut into, right, the debt that you owe. So absolutely, tenants should not sort of feel that they're powerless in these proceedings. They may have valid defenses to the proceeding, like the condition, potentially rent overcharge claims, potentially issues with the building certificate of occupancy, which may bar them from collecting rent. There's a myriad of defenses that tenants may have, and just because your landlord sues you doesn't mean that you just sort of have to roll over and accept, oh yeah, I owe this money. No, you likely have defenses to the action, and absolutely, those should be litigated.
We don't have additional questions for now, so if there are any other topics or final details.
No, I'm good. We'll wait another minute or so and see if anybody has any other questions. But yeah.
Yep, our Q&A is open.
Correct. That is exactly right. One is economic, the other is health. That is right. And you can check both boxes. That doesn't get you any rent paid, doesn't do it. It just stops the proceeding, again, unless the landlord challenges it, right? So, you have to, if you don't file that, right, then the landlord can proceed with everything, right? So, a lot of this is the protections of the eviction moratorium are triggered by the filing of that COVID hardship declaration, right? So, Yeah, that's right. There's two criteria and you can meet one or both. If you meet one, you're good. If you meet, so you don't have to meet both, but that's exactly right.
So we'll wait a few more moments, see
Sure.
if we have any final
Final questions, etc.
comments and questions. If the declaration was in place from February, do you have to complete another declaration?
Good question. Yeah, I touched on that, but no, you do not. You don't have to fill a new declaration. The declaration is the same and has remained the same through the two extensions. It's remained the same hardship declaration.
Question that just came in Spanish. Disculpe, mi esposo está en el lease y otra persona, pero la otra persona se fue en la pandemia. ¿Tiene algo que ver? Solo se quedó mi esposo de encargado.
I guess the only relevance it would have would be that likely your wife would be responsible for the full amount of the rent. If they were splitting the rent that he left, the chances that he or she continues to contribute to the rent, I think, are very much minimal. But the landlord is entitled to the full amount of rent regardless. So that's the only way I could see that impacting that situation.
And we'll give it a few more moments. What about if tenant never called 311 in the past? However, there's emails about heating issues.
Yeah, no, those are good, right? You don't have to call 311 about conditions, right? That's not a requirement to win an abatement. It's just helpful to have it, right? It's a really strong piece of evidence in any sort of litigation, any kind of court case, that an independent inspector from the city went out, verified that the condition exists, and you kind of sort of take away any kind of doubt, right? You don't have to do the pictures, you don't have to do your testimony. Here comes the city said this condition, the city said there's a lack of heat, the city said this was roach infestation, the city said that there's unsafe mold in this apartment, right? The judge just takes that on its face. There's no issue of fact. There's no issue that has to be resolved. That's why it's helpful. It's also helpful because landlords get notified of that. So they can't claim, as they always do, I didn't know, the tenant never told me, the tenant didn't do this. And then you're stuck with trying to come up with the emails or trying to come up with the texts or your testimony that you continuously called them, or the super and you kept telling the super and then the super comes and denies it, the usual nonsense. That's why I always suggest call 311, get a housing inspector out there, have them verify the condition, and then a lot of those things you just don't have to worry about.
Pero debemos las 5 rentas. Tenemos miedo que nos saquen porque la otra persona se fue a México. La renta es de 2,475.
I'm not sure I understand the question. Is there a court case pending? I'm not sure I understand the question.
Sure, we'll wait.
Any tenant that owes money is going to feel risk. They're going to feel pressure. They're going to feel anxiety. That's what's going to happen. I think the question becomes sort of what do you do to deal with that? And that's sort of what we focused the discussion tonight is how do we go about confronting those realities that sort of present themselves front and center for hundreds of thousands of tenants throughout the city, right? They owe money, no fault of their own, 100% about the pandemic. How do we deal with that? And that's been the tug, and that's been the pull, and that's been the issue. It's been an issue that the New York State Legislature, to their credit, has tried very, very, very hard to put up these barriers and these protections, right? they've stopped landlords from evicting people, plain and simple. They tried very, very hard to not only do that, but to stop all of this anxiety by telling landlords, you can't even sue people. You can't even bring people to court. That part, the Supreme Court of the United States, they're very, very, to the right. They said you can't do that. So things have changed a little bit, but there's still robust protections for tenants as far as the eviction moratorium in New York State. And at this point in time, no tenant should feel any anxiety at all that they're going to be put out on the street, because that would be illegal. It would be illegal if a landlord evicted a tenant, if that tenant had submitted a COVID hardship declaration. So I guess to answer your question, you got to sort of see. I mean, if there's somebody left from Mexico that was a contributor to the household expenses, then you suffered harm because of COVID. And, you should fill out a COVID hardship declaration and send that in.
My building is part of the alternative enforcement program, and the conditions of rats still exist in the building. How does the alternative program to get this and other problems addressed in the common areas of the building?
I think the best way to address conditions and repairs broadly is to start what's called an HP action in housing court. I think that's the most effective way. That's what I tell clients they should do. And that's what I would suggest that you and your neighbors do. You start what's called an HP proceeding in housing court. And that's a proceeding, very limited jurisdiction. And the court only can adjudicate whether or not there's a condition in your apartment or your building. And if there's rats, that's a condition. And then they make an order that the landlord has, a certain number of days to correct it. And if the landlord doesn't, there's consequences. They could be held in contempt of court. And then ultimately they can be held in criminal contempt of court, right? They're defying a court order. The court is telling them, I, as the court, am ordering you, landlord, to get rid of the rats. And there's consequences if you don't. That's the most effective way. It's a bit of an ordeal. It can be somewhat, if you have to hire lawyers, it could be somewhat expensive. It is the most effective way to get repairs done for New York City tenants, is the commencement of an HP action.
Who continues paying the tenant rent after they are paid up? Can they apply for Ewrap again?
No. Ewrap has a set defined length that it will cover. It will cover rent from March of 2020 through July of 2021, and under some conditions, they'll pay prospectively for 3 more months. So August, September, October. So that's the extent that they will pay. It's not an ongoing assistance program. It's the design, the policy, right, is to protect people during the months of the pandemic. So doesn't cover, if you owed rent in, before March of 2020, before the pandemic, before the shutdown, Ewrap will not cover that. If you owe rent, going forward, because you're not going to be paying for a while, Ewrap's not going to cover that. So it covers the months that I talked about, and those months only.
What if you are paying rent but have problems with paying electricity?
Yeah, I think there's a provision. I think there is some provision. There is in the Ewrap that'll cover electricity costs too. So if folks have, arrears or owe a bunch of money to a utility provider, they should apply for Ewrap. That is part of the Ewrap program. They will pay electricity costs. They will cover electricity debts.
Yeah.
What is the policy if you ask landlords to remove someone from the lease? Are they supposed to do another apartment application? I've been in my apartment for 18 plus years.
So a landlord can't remove someone from a lease unless it's that person that's asking to be removed from the lease. And they won't be removed from a lease because the landlord would never take a name off a lease while that lease is still in effect, because they want to hold that person liable for the rent. But if the lease ends that person can say to the landlord, I'm surrendering possession of my apartment and take me off the lease. But it has to be that person, right? You can't have a situation where someone else says, take Mrs. Smith. I rented apartment, Jesse Gribben, with Jakari Green. We rented apartment together. I can't tell the landlord, take Jakari's name off the lease, because Jakari might not want that. And then, right, so that's not, it has to come from the person who wants to be taken off the lease. That's the only way that you could take a name off the lease. Otherwise, you'd be extinguishing the potential rights of someone without any authority to do that.
Mhm.
I rent a room since 2 years sublease on May 6th, 2021. This is a lengthy question. Fire happens in above apartment, affected from my rooms, ceiling collapse and other. I had decisions from housing court on August 10th against the landlord to repair the apartment in 30 days. And it should give me notes before notice before starting 72 hours to go out, 3 weeks. August 13th, 11 p.m. I found the door locked out. I did not receive any notice. I called police and 311. They told me to go to court. August 27th, go to court. The judge gave me 1 hour to go to my apartment to take my medicine and important things. I got to the apartment. I did not find anything. Called 911, the police. He told me to return to court. I returned. Court employee gave me notes to go to Supreme Court. Now I don't know what to do, where my belongings, and if I can return in the apartment or not. Looking for assistance.
Yeah, you gotta get in touch with Palante. I'm not gonna be able to. That's a lot. That's a lot
Yeah.
going on. I don't really. It wouldn't be fair to whoever asked the question for me to try to chime in and give legal advice. I'm just not sure from that question whether or not the displacement is the result of the fire and then their need to clear out the apartment in order to rehabilitate the apartment, or if the landlord took advantage and illegally evicted the tenant. But certainly I would suggest you probably should try to get in touch with Palante and Alcia. There's a lot going on there, and that's something that is not going to be easily addressed in this type of forum, I don't think.
Right, I'm gonna put our number in the chat section, and you can give us a call on Monday, and then
Good, you should.
Yeah, we can further discuss it.
We do not have currently any pending questions.
All right.
Okay, our number is 212-491-2541. And we're open from 10:30 to 7 p.m. Monday through Friday.
Looks like we have no pending questions.
Okay.
Okay, so I guess we can conclude tonight. Jesse, do you have anything any last words or?
No, I'm okay. Just I appreciate the opportunity to talk with everybody. These are challenging times. They continue to be challenging times, and everybody gets credit to some for being informed, for reaching out, for seeking counsel, seeking advice. And there are resources available, and tenants have rights. So nobody should feel powerless. Nobody should feel that they're at a loss. You reach out to Palante, avail yourself of services available, and we'll get through this. We'll get through this together.
We do have a poll up, just our standard survey that we post towards the end. If you do see that pop up on your screen, please take a moment.
Okay, so I guess that will conclude tonight's webinar. I want to thank Jesse for his time tonight and being so informative and breaking down the extending of the eviction moratorium. and what it means to tenants. I think a lot of us were confused on the implications, but now, we're able to understand it better. If you are seeking assistance with filling out an Ewrap application or help with a hardship declaration form, you can contact us. I'm gonna say the number again at 212-491-2541. Wait, 212-491-2541. Or you can email us at palante@palanteharlem.org. We are now holding Palante Bodega Fridays, which is our weekly food pantry, where we give out fresh groceries. So I'm gonna have Robert drop the sign-up sheet in the chat for anyone looking, to be a part of that. Also, we are looking to be a top-rated nonprofit this year for the 8th year consecutively. So if you could please if you could please leave a review on us on the link that's getting dropped in the chat section right now, we would greatly appreciate it. Yeah, just if you do have any follow-up questions or, seeking any type of housing assistance, you can call us Monday through Friday, from 10:30 to 7 p.m. and we're available. Okay, sorry, I can't find it. Send. Are anybody having issues with getting the link?
Just posted both of them.
Okay, you posted, okay. Okay, yeah. So thank you, Jesse, again. Thank you, Robert. Thank you, Daniel. And thank you to our 31 attendees who have stayed here for this amazing webinar. We will continue, so look out for another invite for our next webinar next week. And I hope everyone has an amazing weekend. And this webinar will be available on YouTube on Monday. And I will personally send everybody in this chat a follow-up with that recording. Okay, so everybody have a good night. Oh, and actually, if y'all could take a moment to fill out this poll that's up, it would be really great.
Take care, everybody.
Okay, have a good night, Jesse.